In this lecture, we will discuss about Article 14 of the GDPR. That is, what information an organization should give to the data subject when data is not directly collected from them. As per Article 14.1, when personal data have been obtained from the source other than the data subject, then controller shall provide following information to the data subject. First information is about the identity and the contact details of the controller and where applicable controller's representative. Second information is about contact details of the data protection officer wherever applicable. Third information is about purpose and legal basis for the processing. Controller also need to specify the categories of the personal data collected. Categories of the personal information may include contact information or payment information or maybe purchase history or website usage data such as cookies, analytics or demographic information. The recipients or the category of the recipients of the personal data. If the controller plans to send the personal data to another country or international organization, they should mention it and provide info about the safeguards in the place. Also, they need to tell the data subject how to get a copy of these safeguards if required. So, this is about Article 14.1. As per Article 14.2, following additional information should also be provided to ensure fair and transparent processing. First one, the period for which personal data will be stored. Second one, legitimate interest pursued by the controller or by a third party. Third one, different rights of the data subject such as right to access the data, right of rectification, right of erasure, etc. Fourth one, details about existence of right to withdraw the consent at any time. Fifth one, right to lodge a complaint with a supervisory authority. Sixth one, details from which source personal data is collected and whether it is coming from publicly available sources. Seventh one, details about existence of automated decision making, profiling and meaningful information about different logic involved. So these are the requirements as per Article 14.2. Additional information to be provided to the data subject. Article 14.3 prescribes the timelines within which information should be provided to the data subject. So as per Article 14.3, controller shall provide the information referred to in Article 14.1 and Article 14.2 shortly after getting the personal data and no later than 1 month. In case if the data will be used to communicate with the data subject, this information should be shared at the very first communication. In case if data will be shared with some third party, then this information should be shared with the data subject before disclosing the data to the third party. As per Article 14.4, if the controller plans to use the data for something different from the original purpose, they have to tell this different purpose to the data subject before processing that different purpose. Details should be shared about new purpose and any other important information as mentioned in Article 14.2. Article 14.5 prescribes certain exemptions. Article 14 shall not apply where the data subject already has the information. Providing such information proves impossible or would involve a disproportionate effort. Disclosure is expressly laid down by the union or state law. For example, as per regulation, bank may require to report data to the authority. So here Article 14 will not apply. Also, where personal data must remain confidential, subject to an obligation of professional secrecy, as regulated by union or member state law. For example, professionals like lawyers, doctors or therapists must keep their clients' information confidential. So, please understand, obligation under union or member state law takes precedence over the need for the consent under GDPR. So, these are the exemptions according to Article 14.5. Let us now discuss Article 14 in a nutshell. Article 14 have 5 subclauses. 14.1 says that when information is collected from the other source, that is source other than the data subject, then controller is obliged to provide certain information such as contact details of the controller and DPO, purpose and legitimate interest for the processing, recipients of the personal data and other such information. 14.2 requires some additional information to be provided such as data storage period, different rights of the data subject, from which source data is collected, and details of automated decision making and any other such details. 14.3 discusses timelines within which information to be provided to the data subject. 14.4 says that if the controller plans to use the data for some different purpose than the original purpose, then they need to tell the data subject before processing that different purpose. Article 14.5 says that Article 14.1 to Article 14.4 don't apply if the person already knows the information, or providing the information is too difficult, or the law requires the disclosure and there is professional secrecy obligation. So this is about Article 14. Let us now discuss some of the key aspects of Article 14. Please understand, Article 13 will apply when data is directly collected from the data subject, whereas Article 14 will apply where data is collected from the third party. Point number 2. So, additional requirement for Article 14 is from which source the personal data is collected, and if applicable, whether it came from a publicly accessible source. So almost 13 and 14 are same, but this is the minor difference. Okay, in case of Article 13, controller must inform the data subject at the moment data are obtained from the data subject, because in Article 13 data is directly obtained from the data subject, whereas in Article 14 controller can provide information later but not later than 1 month. So these are some key aspects of Article 13 and Article 14. Let us now recap provisions of Article 14 by way of multiple choice questions. Let us now discuss the first question. When must a controller provide a data subject with information if personal data have not been obtained from the data subject but obtained from the third party source? Correct answer is option A. Within a reasonable period after obtaining the personal data but no later than 1 month. This timeline is defined in Article 14(3). Question. You are a data protection officer at HDA. The company has obtained personal data from a third party source for marketing purpose. What information must the controller provide to the data subject in this scenario? Correct answer is option C. This is as per requirement of Article 14(1). So as per Article 14(1), following information should be provided to the data subject: identity and contact details of the controller, contact details of the data protection officer, purpose for the processing and the legal basis for the processing, categories of the personal data concerned, recipients and the categories of the recipient, and in case of international transfer, details about the same. That's all for this lecture. Thanks for watching.